My lord, this is petition for the grant of anticipatory bail, your lordship, under section 147, 341, 323, 307, 504, 379, your lordship. Petitioners, the informant, your lordship, and the accused person, father, your lordship, and the husband, they are own brothers, your lordship. As per the FIR, my lord, I may be permitted to read the FIR, your lordship. घुटने पे चोट लगा, एल्बो पे, इसी में लिखा है माय लॉर्ड, लोग जख्मी, मेरे पुत्र की पीठ एवं दाहिने हाथ के कोहनी पर काफी चोट है, हाथ के कोहनी पर।
इम्प्यून ऑर्डर में लिखा है इंजरी ऑफ द इन्फॉर्मेंट सन ग्रीवस,
बट माय लॉर्ड मे काइंडली सी द लास्ट
इंजरी.
My injury report is not an but your lordship may see the impugned order.
Where have you said that the observation of the judge is incorrect factually, that it is not grievous, it is simple?
My lord, may kindly see the impugned order. My lord, last paragraph.
वो बताइए, unnecessary इधर उधर बहस करने से तो कुछ होगा नहीं
जी.
तो एडवोकेसी का मतलब है कि कोर्ट ने सवाल पूछा, उसका जवाब दीजिए, नहीं जवाब है तो
पैराग्राफ 10 your lordship, पैराग्राफ 10.
पैराग्राफ 10 तो मैं देख रहा हूं, दोनों औरतें हैं, घर में डिस्प्यूट है, उसको तो मैं देख रहा हूं. ये तो नहीं पूछा आपसे पूछा, आपने स्टेटमेंट दिया हल्की फुल्की इंजरी, इम्प्यून ऑर्डर कहता है ग्रीवस, मार के अंदाज से जो एलिगेशन है उससे ये नहीं लगता है कि ग्रीवस इंजरी होगा, लेकिन आपने अपने पिटीशन में लिखा है कुछ और बहस आप इधर उधर की कर रही हैं, ये गलत है. Young lawyers should respond to the query of the court and they should come with a specific reply. बहस का मतलब ये नहीं होता कुछ भी बोल दें.
My lord is correct, but my lord, that specifically it has not been mentioned. But
that's all right. So you say that you have not stated that, but don't try to fudge the question.
I'm sorry, your lordship.
That doesn't look good, especially young lawyers. And I am very particular in reminding young lawyers that you have to go a long way. When a court is asking a question, give a pointed reply or say that you can't reply. The court will not press you. The court will only grant you time to find out, and the court will help you.
Oblige, my lord.
Why do you think that you are so wise that you will deflect the questions of the court?
No, my lord, I apologize for that.
You should understand that the court is, I mean, any person who has spent more number of years in this institution would be having, more experience than you. पूछा सवाल कुछ, बोल रहे हैं कुछ और लगातार बोल रहे हैं. ये सब पता है हमें कि फैमिली डिस्प्यूट में पार्टीशन के समय लड़ाई हुई, एक भाई को नहीं देंगे, आपको बेल मैं ग्रांट करूंगा, लेकिन जब सवाल पूछे तो उसका जवाब दीजिए, अदरवाइज यू विल स्पॉइल योर केस.
आई अपोलोजाइज माय लॉर्ड.
यस, घर में क्यों करें परेशान, इनको तो बेल दे देते हैं, उनको जेल वेल जाएंगे देखेंगे, इनको क्यों करें. बड़ी आपकी बहस से मैं भी रिजेक्ट कर देता.
आई एम सॉरी माय लॉर्ड.
देखिए, इंफॉर्मेंट, the petitioners seek bail in anticipation of their arrest in connection with so and so. The petitioners are alleged to have assaulted the son of the informant, as a result of which he has received grievous injuries. Learned advocate has pointed out that from the narration made in the FIR, it would become very clear that a dispute arose between the families of two brothers over partition of family property. In the process, the father of petitioner number 1, who is husband of petitioner number 2, who is also the husband of petitioner number 2, is said to have assaulted the informant, his own brother, on his head. When Gaurav, son of the informant, came to his rescue, he is said to have been assaulted by the petitioners. The Land Council for the petitioner has submitted that though in the impugned order there is a reference of the injuries, though in the impugned order it has been observed that the injuries suffered by Gaurav is grievous in nature, but the Land Council for the petitioner submits that no weapon has been attributed to them, and the injuries were not intended to be committed. The injuries were not intended to be inflicted. It was a fight between members of the family. It was a fight between the members of the family where both parties have received injuries. As opposed to the aforesaid contention, the Land Council for the informant, however, has submitted that the assault made by the petitioners has caused grievous injury to one of the victims. There is further allegation of snatching away personal belongings of the members of the prosecution party by the petitioners, by the petitioners. However, looking at the background facts and especially noting that the whole occurrence arose during a dispute which erupted while the property was being partitioned amongst two own brothers, the petitioners number 1 and 2, who are ladies, and petitioner number 3, who is a young person, is directed to be released in the event of arrest or surrender 10,000.
Obliged, my lord, obliged.